UBC Studios in Kampala. This is Good Morning Uganda Extra.
Hello and thank you very much for being with us on UBC TV. Welcome to the Extra. I'm Robert Chirabo Nyonyitono. Now, this very week, the Constitutional Court nullified, that is the Computer Misuse Act as amended in 2022, citing that there wasn't enough quorum in Parliament when this bill was being passed, but also that it infringes on the fundamental human rights. Now, many talk about sections that did specifically nullify, others look at the bill in its entirety, and some are wondering what exactly now happened. What is the situation on ground? And I said, no, I don't have the expertise to discuss that, but I have friends of mine that are advocates, say are lawyers, and they come from a body that we all respect as Ugandans, that is the Uganda Law Society. Now, join me welcome my guest this morning is Siko Arthur, who happens to be the treasurer of the Uganda Law Society. Definitely, there you can only be there when you're a lawyer. That is when you are part of the society. You're most welcome, Arthur.
Thank you so much. Good morning, our viewers. My name, as earlier said, is Siko Arthur, the treasurer of Uganda Law Society. Uganda Law Society, for those who don't know, it's an entity that combines all lawyers in the country. And our head offices are in Kampala. Yeah, indeed it is true. We woke up with good news. The Constitutional Court made some decisions. The Constitutional Court is a court that actually interprets the Constitution. If any law is in controversy with the Constitution, if you have any issue that probably a law has been made and you probably think it is in contravention of the Constitution, the court you go to is the Constitutional Court. It is the first court that you go to, the Constitutional Court. Of course, you can always appeal. If you're dissatisfied with the decision of the Constitutional Court, you can always appeal to the Supreme Court. So, of recent, Uganda Law Society, some advocates, media entities, and civil society organizations filed a constitutional petition against the Attorney General. The Attorney General is the government representative challenging the Computer Misuse Act that was amended in 2022. You know, the Computer Misuse Act has always been there since 2011. However, there are some changes that were made to probably broaden and probably highlight areas where they thought that it would help in the administration and safety of the rights of Ugandans. So they came up with that Act of 2022. And the Uganda Law Society plus the other petitioners, like I've told you, had some issues, and definitely they went to the Constitutional Court. One of the issues they had with that particular law that was made in 2022 was the fact that it was contravening international principles for human rights. For those who are out there, you should understand that Uganda is part of the global world, meaning it can ratify, it can probably go by certain international provisions. And one of them, we have the African Charter on Human Rights that actually enshrines the Constitution, enshrines the freedoms and rights of Ugandans. So, of course, even our Constitution itself, Article Bill Chapter 4, it provides so many rights, and one of them is the freedom of expression, freedom of opinion. Those are all rights that are provided for under that bill. So the society thought that particular law that had been made was in violation of not only the Constitution of the Republic of Uganda, but also international statutes, which Uganda ratified. Uganda accepted to promulgate laws that are in line of those international standards. And then also the society felt that there was a procedure issue. There was a procedure issue. The Constitution of the Republic of Uganda provides procedures under which the Parliament has to go through before it actually comes up with with a certain law. So we felt that those issues were very, very important issues, and we took that matter to the Constitutional Court. Of course, the matter was handled by 5 justices of the Court of Appeal, and the matter has been going on for quite a number of years, and recently, this week in particular, there was a ruling, a fundamental ruling that has actually changed the course of how not only the parliament, because it has laid out, it has really clarified some issues that were earlier on said in the case of Paul Kawanga Semogerere. He had also filed a matter earlier on in court, and the court pronounced itself on some procedural issues. I think they must have taken them seriously to some extent, but this court has re-emphasized that some of those provisions that were said and now are said in this particular case have to be really looked into. And one of the issues through the leading judgment of Honorable Justice Irene Mulyagonja, she really talked about the issue of quorum. That in passing of this law, or in passing of any law, because now these laws, this judgment will have to be applied in respect to other laws, there has to be quorum. Okay. In reading, and of course in the final passing of that particular law, there has to be a quorum that Parliament has to satisfy itself to that indeed there is quorum. And the quorum in this particular case, we mean a third of the entire Parliament. We have around 500 MPs, so probably approximately around 150, 160 should be the quorum that should be available on each reading to ensure that civic participation, because remember those members of Parliament represent the people, and by being there, that means civic engagement. Then the members of Parliament are representing the people, and of course we assume that they are doing whatever they're doing for the people. So the issue of quorum was one of the issues that they looked at. Of course, there was that issue that the record book, Parliament also has a record book, an attendance book, where people probably sign that we are attending a certain Parliament, and probably if you look at the record book that was availed then, it could show a particular number of people that were available on that particular day. But court went ahead and emphasized that there must be also a physical counting. Leave on the issue of the register book. Yes. The Speaker of Parliament has to confirm, and by confirmation, there has to be physical counting to confirm that indeed this is the number of people that is present before a reading actually takes place. Okay. So that is an issue that the Constitutional Court has really emphasized. Of course, we have been having issues of yes, the no's, when they say how many are in support, then yes. And of course and you see there is a challenge that there are some people who have the voices are deep. So sometimes you can hear the yes, yet there are very few. But since some people who are saying that they have deeper voices, someone with health issues, someone is saying no, oh yes, but you can't actually hear that person very well. So the Constitutional Court has been pointing out on all such issues that it is very, very important that the Parliament actually has to confirm, and by confirmation there has to be that physical counting. If the numbers are not enough, if you look at the rules of procedure in Parliament, if the numbers are not enough, the Speaker of Parliament has a right to adjourn the sitting for 15 minutes, just to ensure that the sufficient quorum is indeed present. And if they come back again and the numbers are insufficient, they can always adjourn the matter indefinitely until such a time when the Parliament or the Speaker can actually confirm that indeed now we have sufficient quorum. So that is one of the reasons as to why that particular act was declared to be in contravention of the Constitution. Remember, we are a republic and we have a constitution. And by constitution, we are governed by constitutionalism. And by constitutionalism, we assume that all laws should be in conformity with the constitution. That is one of the cornerstones of this country, that all laws that are made align with the constitution. They shouldn't contravene the constitution. And that is why you are seeing some of the provisions that were nullified are nullified because they are not in tandem with the constitution of the Republic of Uganda. Of course, the other point that I talked about earlier was the issue of rights. Rights are provided for under Chapter 4 of the Constitution of the Republic of Uganda. There are so many rights: right to life, right to education, right to health, right to a family. Those are all rights that a Ugandan has. There are so many rights. But in this particular case, one of the rights that came out was the issue of freedom of expression. That you can express your ideas in a particular way. You can express your opinions in a particular way through any media, be it through a computer, through print, like typing or writing on paper. So all those rights are protected under the Constitution of the Republic of Uganda. And the Computer Misuse Act had certain provisions. If you look at the amended act, it had certain provisions which we thought as Uganda Law Society that these provisions were in contravention of the Constitution. One of the provisions therein was the fact that probably you have to seek consent, for especially the journalists are the ones who are so much affected. In case you want to release certain information, or you want to take a certain picture or certain media on any person in this country,
you must have their permission.
You must have their permission.
Which was
almost impossible.
Impossible,
because there are certain instances where it is almost impossible to get the permission, and yet that event is just happening at that particular moment. So we thought that provision was really so unconstitutional. Computer misuse itself, having fake identities. Of course, I'm not encouraging Ugandans to have fake identities on social media, but having identities that are not quite clear, anonymous. If for you people who normally attend Zoom meetings, there is even that provision that allows anonymous attendance. So that law was actually prohibiting all that. That whatever you do in light of the computer, if you're using gadgets, computer or electronic gadgets, that it has to be in line of those provisions of that particular act. So we as lawyers thought that such provisions were really contravening the Constitution of the Republic of Uganda, because earlier on certain laws had actually, certain cases had actually come out to amplify what we are earlier on saying, that people should be allowed to express themselves without any fear, any coercion, that if I do this, I'll face such repercussions. And indeed, we have seen people who have been...
quite a number of them.
Yes, who have been...
the Computer Misuse Act is amended, has led to arrest of a number of people.
Yes, people have been arrested.
Dozens, not hundreds yet, but dozens. People
are in trial. Others have already been sentenced. So the question is, even what is now the implication now, especially now that the courts of law have come out to clarify on the issue.
And that is why I think also the public is very eager.
Yes.
We have people who are on trial over the Computer Misuse Act.
Yes.
We have those that are serving sentences.
Yes.
What does this mean now?
Yes.
Those that are serving sentences, already they were convicted.
Yes.
And maybe they were sentenced.
Yes.
But there are those whose cases are still in the pipeline. They're in courts of law. Some come from Chitalia, some Luzira to courts and go back.
There are even those who are still at police. Investigations are still ongoing. Yes. So every Ugandan, of course, by virtue of that law, the orders were that there was a permanent injunction. Permanent injunction means that all activities, all trials, all actions that derived their mandate, from those provisions of that particular law, especially the one that was amended, were declared null and void, and therefore government is stopped from relying on them, or any person is stopped from relying on them to pursue a certain cause. And one of the causes, of course, like you've said earlier, is prostitution. Prostitution begins at police level, where probably you're called at police to make a statement and also assist in investigations. So all matters that are currently at police and people are being investigated over such provisions of the Computer Misuse Act as amended in 2022 that has been annulled by the Constitutional Court have been terminated with immediate effect.
Okay, very interesting. And of course, welcome home.
Yes.
For those of you, you know, and Uganda have a saying, yakwagaliza ekomera akwagaliza kufe komera ntana yako.
Yes,
Meaning that he who wishes you to go to jail is more than a person who wishes you to die.
Yes.
Now, that said, the repercussions, how do you think we are going to manage this situation, Arthur, in absence of the Computer Misuse Act, where these provisions were removed? Because there's excitement.
Yes.
We are in a time where we have a group of people called bloggers and TikTokers.
Yes.
They are very good, I must say. They do a tremendous work, many of them.
Yes.
But also there are those that do things that are unexplainable.
Yes.
They are ready to have verbal artillery with anybody they have never seen, but they are willing. They involve themselves in battles, they defame people, they, whatever I can say that someone can do using the internet, they have done that. Now, in absence of such a law, like it was, how are we going to move forward from the legal perspective? Yes,
yeah. In fact, before I go on that issue, I want to talk about, because I talked about people who are in police. There are people who are now under trial, over such sections that are provided for under that impeached act. Of course, even such trials now are going to be terminated. All it takes is the accused person to bring. Of course, it is now. It is now. Judicial notice. Judicial notice means now court is aware that such provisions have been nullified. So, by virtue of that, they are going to terminate all such trials. Anyone, even as long as they haven't been sentenced. The problem is if you are earlier on sentenced. That means you are sentenced at the time when the law was there, and now court is functus official. But those before court has actually sentenced such people, you can always call for termination of such cases. And of course, there are remedies. If you have been imprisoned, that means you have been imprisoned illegally, you can always seek for probably compensation from government. You can always take redress from courts of law, civil courts of law, where you can actually be compensated by the government. Of course, where does that now leave us? That is a very, very important question. Is that now an open gate for people to start?
We've been cast into the den of the lions.
To start abusing people, to start sharing pictures of people irresponsibly. Is that an open gate? Of course, that is not an open gate. We still have laws that actually protect people. For example, we have that law for defamation. In case you share out anything that is most likely going to demean someone, you can still be held accountable. You can still be held accountable. And you have seen quite a number of judgments of court where people publish stuff, people say some information that they don't even have any backing overall. If you don't have any evidence or any iota of backing, such people, the law still provides for such redress, meaning you can still be held accountable. That Ugandan is out there who thinks that now I can say anything that I want. After all, the gates are still, now they are open. You can be held on. And of course, it is also constitutional provision that everyone has a right to privacy. That is also a right of someone, meaning even you who is out there who thinks now you're going to start sharing pictures of probably kids or what, that is also going to be, it will be in violation of the Constitution. And like I've said, anyone who feels threatened by any actions that contravene the constitution of this republic can always actually seek redress in courts of law, including but not limited to the constitutional court. So still there are still some guidelines. Of course, it is now up to the Parliament of Uganda through the relevant ministry and through, of course, guidance that shall be given by the Attorney General to see how they can actually factor in such changes and recommendations as given by the Constitutional Court, because we believe those are very, very important constitutions. In fact, in that same law, the case of, the offense of criminal libel, where someone, it was a provision, section 162, where initially still it was an offense of publishing or printing or disclosing any information that is also likely to demean. The parameters weren't well set out. Because the Constitutional Court was very clear. It said that for such offenses, now you have to really elaborate on the parameters. Yeah, you shouldn't leave it to be so vague in a way that someone doesn't know the limits of which he or she is supposed to operate in. So we believe this is now an opportunity where now the stakeholders can actually see that now if we are to come up with any law, we have to ensure that we are in line of the parameters of the law, and that is so good for constitutionalism. Like we had earlier on said, this is a testament that separation of powers is still cherished in this country. By separation of powers, for those who are out there, it means that all entities can operate independently without any coercion or influence or invisible hand to determine what they should do or what they shouldn't do. We have seen a law that was actually made by Parliament independently, and we are seeing of course, these laws come from the executive. Yeah, in the making of laws, the policy comes from the executive, taken to the legislature, that is the Parliament, which makes the laws. And if anyone has a problem with the law that has been made, you can go to the courts of law. And we are seeing that even the courts of law have been able to make any decision without any interference. Of course, that is a testament that, like I've said, it is good for growth of that principle of constitutionalism that provides for separation of powers.
Yes.
Each entity to operate independently without any interference. And the other important aspect that we really brought out, especially through the petitions, of course, court only nullified that entire law on two important issues, like I've earlier on said. The issue of it being not in conformity with the procedures, quorum, and in contravention of the Constitution. But we also brought out an aspect of, especially in that petition, of engagement of the masses, civic participation, where we do believe that sometimes they have to consult. They have to consult the citizens of this country, because remember, Article 2 of the Constitution of our country provides that all power, all mandate derives from the people of Uganda, and everything has to be done in light of that power. So we do believe that there has to be enough consultation, especially with the public, to ensure that their views are actually captured. Yeah, because like we have been saying here, there are some things which we think that if probably they had consulted, to be a better, to be a better law. By far and large, it is a good law, but it just needs to be amended to ensure that it doesn't conflict with the constitution of our country, because any conflict automatically just puts it on the sideway. It means that such a law is in contravention and can't be applied. And of course, like I've said, there are those matters which are now in court. We have so many people who are in courts of law.
Those are already out.
Those ones, they're not out by now, but they have to go to, have to apply. You know, the issue of court, you don't just say now the law says this, please release me.
Please, can you release me?
No. You have to go back to court. You have to make your application, and of course back it up with the information which I've said is now judicial notice. Every court of law is assumed to know that that law or that judgment is in place. Yeah, so by virtue of that, once they make their application, they will automatically be released. Those who are under investigations in on criminal trial. They should also, for now, those investigations will have to be stopped unless there are any other investigations. This is very good for Parliament because now Parliament will now reorganize itself.
Okay.
Especially for now that we are about to enter into the 12th Parliament.
12th Parliament.
Yeah, the new parliamentarians.
But after this issue of quorum,
yes.
I know you're not a politician, you're a lawyer.
Yes.
But how do we arrive at it? Because I remember the anti-homosexual or whatever, also there was that thing of the lack of quorum.
Yes.
The first before the amended one.
Yes.
Now even here I have lack of quorum. I want to ask myself,
yes.
Doesn't the presiding speaker or the deputy know that I don't have quorum?
Yes.
Then second, why is it challenged that very day that we are not enough?
Yes. There have been two challenges, like earlier on indicated. There has been over-reliance of the attendance book. Attendance book means they assume whenever you enter, you have to, there is that registration. And I think it is going now to call for digitalization because verification, there has to be verification to confirm that indeed these persons were present. Yeah, and by present, people should know that Isiko Arthur, my position was a yes. Yeah. Then any other person that his position was a no, and that is going to call for digitalization, of course.
Okay.
Yeah, where probably seats will be marked, that so and so sits on such a seat, and probably the answer is a yes or a no, and that of course will create transparency at the end of the day, because people have been hiding under the ayes and the no's. Yeah, yeah, there hasn't been that verification that someone can actually tell that someone has said yes or no.
No. You just assume.
You just
the
assume,
eyes have it.
depending on the sound. If the sound is higher or lower, you can easily tell that probably the no's are saying no, they're not in agreement with it. So that is very important, and we believe the 12th Parliament coming into place shall be able to look into this law, and probably it will assist them in legislation, because now they will be very, very keen when it comes to the issue of quorum, which is one of the fundamental principles when it comes to governance. Because at the end of the day, there has to be, people have to be felt that indeed they are really participating in whatever is going on. So we as the Uganda Law Society, we are grateful for whatever has been declared by the Constitutional Court. This was something that we have always waited for a very long time, because now we do believe that it is strengthening governance issues and the rule of law in this country, and of course protecting the rights of the citizens of this country. And we do believe that by doing so there will be nation building. There will be that development, because at the end of the day, it is one of the key cornerstones of this country. Rule of law, it is a cornerstone. It is something that we believe that if it is adhered to, I can assure you, development of this country will be very, very good. So that is something we as the Uganda Law Society, we commend the judiciary for taking steps, and we even encourage, because we have other cases.
Sure. Are there other laws that...
Yes, there are other laws that we do believe that probably should be looked into. Yeah. So many of them, the controversial ones. I don't want to mention all of them because I may take an entire day, but we do believe courts of law should look into them and probably make timely judgments, because now our worry is that now people who have been incarcerated because of such laws, yeah, some are still serving now the sentences, probably have been sentenced for 1 year or 2 years, yeah, or 3 years, yeah. So now they are liberty. Yeah, how will they feel? They are torture. You know, we have rights which are derogable and non-derogable. Derogable meaning they can always be done away with. Yeah, of course, in light with.
That is derogable.
Derogable. And of course, that is light of the law. Non-derogable, they can never be like torture. Now, we do believe that now such persons, challenges, they're undergoing torture. But of course, all is not lost. You can always appeal, of course, especially if the time hasn't expired. But even if it has expired, you can always seek extension of time, where you can always get redress. You, the Ugandan out there, you shouldn't feel sad that now it has been passed, but my relative was already sentenced. Yeah, now I have nothing to do. No, there is always redress in courts of law. You can always seek for an extension of time within which to appeal, especially in light of the new developments. And probably the courts of law will listen to you and probably give you justice at the end of the day, which will actually ensure that each and every one has, and that person enjoys his or her liberty. So that is something that we really implore, and we think that it is a step in the right direction. Yes.
Well, that is Isiku Arthur, who is the treasurer, that is Uganda Law Society, with commending the courts of law, most of the Constitutional Court, for that ruling regarding the Computer Misuse Act as amended 2022. Now, of course, those that are still undergoing trial, well, luck came your way. But also when Arthur, you say that it is not automatic, there is a procedure you have to go through.
Yeah, it is not automatic. You have to, like I said, you have to really apply to the courts of law. And by applying, definitely you will actually receive justice. And of course, this also goes to the Ugandans out there. There are so many provisions of law. This one is just prominent because it has come out, but there are so many laws which have come up in this country where people are being prosecuted in the courts of law. If you feel that you are being prosecuted, but what they are doing is in violation of the national law, yeah, always feel free to reach out to the Constitutional Court. And even you have other courts, yeah, though they may not have that constitutional mandate, but if you feel anything you are doing is safeguarded by the law, always feel free to file your defenses in courts of law. The biggest challenge you have in Uganda is people feel that once a case is opened up against them, yeah, some of them just want to shun away from those agencies. For example, if investigations are ongoing, you hear people running away, hiding away from the police instead of assisting it in pursuit of whatever they're doing. We do believe that such people should understand that you can even raise such issues with even the lower courts, that is magistrates court, even the high courts, and definitely you will receive that justice that probably you are longing for. Yes.
Well, time has come to an end. We will be having a recap of Behind the Headlines, but before I let my guest go, Arthur, in just a minute, let me have your parting shot.
Yes. First of all, I want to thank the Ugandans out there who have been following the developments that are not only happening in the judiciary sector, but the country at large. Like I said, we thank the judiciary for coming up with this timely judgment, for clarifying on this issue and fulfilling their constitutional mandate that whenever there are any challenges to do with the interpretation of the Constitution, they always come out to dispense justice on a timely manner. We really commend them for that. We also implore the legislature to take the decision of this the judiciary in good faith and probably learn from it and make changes where necessary, and ensure that at the end of the day Ugandans are protected. I said earlier that this is not purely a bad law. People shouldn't celebrate entirely that it has been thrown out. It also had some good aspects. Yeah, it was protecting rights to privacy, assuming someone just takes your picture and shares it, and it has that possibility that it might actually affect you in terms of demeaning you in the public, or even affecting your right to privacy. Talk about young kids, someone who is below 18 years just sharing their picture, probably without the consent of the parents. So it had some positives, but what they have to align with is to ensure that it is in conformity with the Constitution of the Republic of this country, because like I said, rule of law is a key cornerstone of any development of any country. If you intend to achieve things in the long run that will benefit the country at large, they should base their foundation on the law, because if you do not base your foundation on the law, then you definitely you will get challenges, and challenges are not good for development. So I thank you so much. Thank you for listening to us. Those who have issues, please feel free to reach out to Uganda Law Society. Uganda Law Society is an entity that provides free legal services. It assists government on matters of the law. It advises government and the public on matters concerning the law, both incidental and ancillary, and we are always open to assist each and everyone. Greetings from the Executive Council of the Uganda Law Society, headed by Isaac Chimazese Makade. Thank you so much for listening to me.
Thank you, Council, for being with us this morning as we've been giving an insight of exactly what transpired, what are the implications, and that has been the Computer Misuse Act, that the Constitutional Court came and scrapped some sections of the Act. Well, see you tomorrow, God willing, to our brothers and the Muslims. Yes, we know tomorrow is Eid. There is no any more other day. So tomorrow, we are sure, and those that invited me, I can guarantee you I'll be at your doorstep, however many you are. Have the best of your day. Good morning.
Live from UBC Studios in Kampala, this is Good Morning Uganda Extra.
Uganda Water and Environment Week UWEC is a week-long event that is organized annually by the Ministry of Water and Environment through the Water Resources Institute. The 9th Uganda Water and Environment Week 2026 will be held from Monday 23rd to Friday 27th March 2026 at the Ministry of Water and Environment headquarters in Luzira, Kampala, Uganda, under the theme Water and Environment for an Inclusive and Prosperous Uganda. This event will involve the commemoration of the annual three-sector International Days, International Forest Day, World Water Day, and World Meteorological Day. Join this event advancing sustainable socio-economic transformation of Uganda's water